Well, good morning, Deputy Gordon. You just showing up for work? Where you been? Oh, I was in a meeting when you came in? Oh, okay. Your day been all right so far? Great. All right. I think we are ready to go. This is a civil default calendar. We've got 5 positions on it. I think 1 has resolved. And then the other 4, we should have the same lawyer for the 2 homeowner condominium association. I bet that's Mr. Conroy. There he is. And then Mr. Bodner, do you represent Itria Ventures?
Your Honor, Mr. Bonner's one of my witnesses.
Oh, okay. So we don't have anyone from Itria Ventures yet. But Mr. Conroy, you've got everyone you need for your 2 hearings?
Yes, Your Honor. And in fact, one of those hearings actually does not need to move forward. We resolved one of the matters that I am here for. It just happened very recently, so I apologize for the last minute. But that's Abbott Square versus Suma Niruganti.
Okay, we'll get to that. I just want to make sure we had everyone here.
Absolutely.
So by process of elimination, one of you is Dominique Young or with Dominique Young?
My name is Dominique Young, counsel for the plaintiff, Desiree Lusk.
Great. And as I understand that one, it's settled. You had filed a petition to confirm an arbitration award. And then in a unique civil move, you'd also said, well, we also want these other damages. I think you can settle it however you want. I think I'm limited to confirming the arbitration award, but it sounded like it's settled. And does Mr. McKinley have a lawyer or has he been representing himself?
The attorney that was representing him that never entered the case is no longer his attorney. Mr. McKinley right now at this point in time is unrepresented.
Okay, but he has entered into an agreement with you as counsel for, are you Ms. Lusk?
Yes.
Hi, Ms. Lusk.
Yes.
But Mr. McKinley's entered into an agreement with you that you believe will, assuming he complies with it, make Ms. Lusk whole.
Right, that's what I filed last night. I filed a motion for continuance on the default judgment hearing today to continue the hearing. So after the 29th, when the second payment is due, Your Honor, and then if he makes that payment, Your Honor, then I'll file a notice of dismissal without prejudice.
Okay, and that is exactly what Ms. Niles forwarded me. Okay, so the emails, Hoopla South, that would be Mr. McKinley?
Correct, Your Honor.
Got it. And he is going to make sure that the arbitration confirmation was for 30,000 plus for Ms. Lusk. You guys will settle it for whatever you want, but assuming Mr. McKinley makes those 2 payments, you'll dismiss and everyone will move on their own way.
Correct, Your Honor.
Okay, one last question. Ms. Lusk, did you not get the original hot dog franchise or it didn't do what it was supposed to do? Or so you paid some money to get a franchise, and does that mean that you actually got a storefront or you just got the ability to open one if you wanted to? What were you supposed to get?
Right, so with the original hot dog factory, I paid the 30,000 franchise fee, and then we were moving into looking for a location to open it up. However, 6 months went by, I got a notification from Google that the meetings were canceled, no one was responding, anything.
Is there really an original hot dog factory or is
Yes, there's a couple of them in Georgia.
just not with you?
Right.
Okay, all right. So Ms. Young, I've got all the proposed orders. I'll sign one electronically. That way no one has to scan it in or anything like that. So I think we're all set. Ms. Niles will keep track. And if we get into August and it hasn't been dismissed, then we're going to bug you to say, why hasn't it been dismissed? And it may be because you want to come back here and get a default judgment against Mr. McKinley.
Right.
Does that work?
That works, Your Honor. I just want to make sure that you were on notice of the motion, and if you need a copy of the order, I would have provided that for you today. However, that's all the business that we have before you today, Your Honor.
Great. You all can be excused. I hope this works out and exactly you can invest in a different venture. All right. Good luck.
Thank you, Your Honor.
All right, Mr. Conroy, why don't we turn to you since there is no one here for Itria and their two cases. And you were telling me position 2 was Abbott Square versus Ms. Niruganti. And you were saying that that has, I don't know what verb you were using, resolved or settled or gone away.
Yes, Your Honor, a little bit of everything, all of the above. There was a settlement, an amount that the parties had agreed to, and we just received confirmation that was received yesterday. So we plan on just filing a dismissal in the coming days. So there's no need to move forward with the litigation itself. It looks like the parties did settle that one.
Okay, so when should Ms. Niles check the docket to make sure this case has gone away?
We'll file the dismissal this week. So if she just wants to check it early next week, there should be a dismissal and a case disposition form and all of the above by next week.
Great. We'll check next week sometime and case closed. So then let's turn to position 3 on the calendar, which is Abbey Road Condominium Association versus Home Savers Atlanta.
Thank you, Your Honor. And yes, that one has not been resolved, unfortunately. So we're prepared to move forward as to the damages portion of it.
Okay.
Great. Thank you, Your Honor. And Your Honor, there will be some documents I'll be putting up on the screen. Do I have permission and the ability to share my screen?
You should have, well, you have the former for sure. You should have the latter. You should just give it a try.
It does appear that I have that ability. Thank you. Great. Your Honor, as the court is aware, it appears that the defendant is in default. They failed to respond timely to the complaint, and therefore they've admitted to the well-pled allegations of the complaint filed by our office. That includes that they own the property located at 3194 Abbey Wood Drive. Pursuant to Exhibit B of the complaint, they've admitted the obligation to pay assessments pursuant to paragraph 14 of the complaint and Exhibit A, which included the pertinent sections of the Declaration of Covenants. As we previously discussed, I do represent a condominium association as plaintiff in this matter, and there is an obligation to pay assessments and related charges as provided in the complaint. Additionally, the defendant has admitted the obligation to pay interest at 10% per annum. This is the statutory interest amount pursuant to 44.3109 of the Georgia Condominium Act. Additionally, they've admitted the obligation to pay cost of collections. That includes the Alliance collection cost. That's a third-party debt collection company that attempted to collect this debt before our office was involved. I do have Michael Bodner with Alliance here who will testify as to those amounts. They've also admitted the obligation to pay reasonable attorney's fees actually incurred pursuant to paragraph 24, and then the litigation costs pursuant to paragraph 24 of the complaint. They've also admitted that the association is entitled to the prayer for relief being sought, which is a money judgment and an order allowing judicial foreclosure of lien pursuant to the Georgia Condominium Act. As previously discussed, these amounts are the amounts that are being sought are unliquidated. Therefore, we filed a number of business record packets with the court pursuant to OCGA 24.803D, 24.9.902.11, and 24.9.903, the classic business record statutory provisions. That included notice of intention to introduce, as well as a declaration certification of authenticity of business record. In each of those packets, there's one signed by the property manager. That's a Vicky Wager. She's the property manager for the association. That affidavit, along with the ledger, proves up the principal amounts owed, which would be the unpaid assessments, late fees, any fines of $12,539.86. Additionally, there is interest that became due. By looking at the rate, the statutory rate times those amounts, you can get the interest of $3,077.14. I am at this time sharing my screen.
Can I ask a question? You're welcome to keep clicking on those things. I have a question.
Absolutely. Yes, Your Honor.
So, what is it about this case that makes the damages unliquidated? I sign default judgments for homeowners and condominium associations all the time, because I don't know if it's just the nature of the homeowners agreement or whatnot, but it's $200 a month or the assessments and they haven't been paid and it's basically admitted by way of the default. What is it here that brings us together?
Absolutely, yes, Your Honor. So my understanding is that liquidated damages apply when the amount certain can be ascertained by looking at the pleadings themselves. In this case, with the inherently with condominium associations, almost always they have monthly dues. And therefore, there would be amounts that become due after the complaint was filed, even if a statement of account or a ledger was included as an exhibit. So those post-lawsuit amounts would be, post-lawsuit filings would be the unliquidated portions. And therefore, the damages hearing would need to be scheduled to allow for the presentation of evidence as to those amounts. Additionally, some of our legal pleadings do not include a statement of account, and in those instances, it would just provide that the amounts sought or those amounts due at the time of a final order and judgment, and therefore would be unliquidated. What is certain is that the obligation to pay those amounts pursuant to the language in the pleadings, the obligation and the different types of amounts, whether it's assessments, late fees, and the different various types of cost, but the amount of those amounts would be unliquidated until proved up at a damages hearing.
Okay, makes sense.
Thank you, Your Honor. And as sharing with the court what I've marked for identification and offering into evidence pursuant to the aforementioned statutes that I cited is Plaintiff's Exhibit 1. This is a declaration and certification of authenticity of business record for Abbey Road condominium. It's been file stamped and copies have been provided to the defendant. And then on the third page, there is an Exhibit A to that declaration of certification, which provides the principal amounts I was describing. Again, this document was previously filed with the court and copies were provided to the defendant. As I just discussed, this is the document showing evidencing the principal amounts I cited as well as the interest. At this time, I offer it into evidence.
Okay, it's admitted. I just noticed the first entry was over $10,000. Has your client sued for condominium fees before? And is there already a judgment, or what's that?
Yes, Your Honor. And so we are not seeking at this time that balance forward amount. You'll notice on the last page that there were amounts that were removed. This is a fairly modest community, and therefore they haven't always had the financial resources to go after the older debt in the past. And so therefore those amounts that appear to be either unsupported by good record keeping or those amounts that look to be barred by the applicable 4-year statute of limitations, those amounts are not being sought. Only those more recent amounts that have gone unpaid. And unfortunately for this particular matter, as well as other matters for this community, they have a large delinquency rate. And so they have many owners that haven't paid in years. Okay. And this is one of them. I am therefore moving on now to the amounts that are additional amounts that have become due and owed to the association. These are amounts that are being incurred by the association. And in this category, starting with the amounts owed to the association, that the association is financially obligated to pay, which includes those for the services for using Alliance CAS. As previously discussed, they unfortunately with this community, they large delinquencies and they don't have a lot of financial resources, and so they look to using third-party debt collection companies. And in this case, it's Alliance CAS, which has done a lot of initial work. I have as a witness a Mr. Michael Bodner, who is the CEO of Alliance, and at this time I'd like to call him as a witness.
Okay.
Great. Mr. Bodner, if you could raise your right hand. And do you swear and affirm that the truth that you are about to, the statements you're about to give are the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And what's your position at Alliance CAS?
I'm the CEO.
Thank you. And what type of services does Alliance provide?
We provide debt collection services for HOAs and condos
Great. And how long has Alliance been doing that sort of work?
for more than a decade.
More than a decade. And what services has Alliance provided to the plaintiff in this matter, Abbey Road?
We collect their unpaid assessments, as well as additional charges, as you've mentioned, interest, late fees, and other miscellaneous charges as well.
And has Alliance been contracted to provide collection services for amounts owed by the defendant in this matter?
Yes,
And are you familiar with this particular case?
yes,
Does Alliance have a routine practice for recording and keeping track of its fees and costs for particular collection matters?
we do. We prepare a ledger that we call the statement of account, and we do that in a technology platform called Collectronics.
And for Alliance fees and cost, when are these placed on this statement of account?
Generally at the time that they're incurred or very near to the time that they're incurred, as soon as actions are completed under our contract agreement with the association.
Great. So it's fair to say at or near the time they become due?
That's right.
Great. And does Alliance keep track of other charges sought by the association?
We do. Yes.
And how does Alliance obtain information on assessments or other charges that might be owed to the client?
We request and get access to ledgers from the association, similar to what you've already shared from Homeside, as you saw on the screen. So anytime we need to make our updates, we always request the latest ledger from the association.
And if the owner were to make a voluntary payment during litigation or before, when the matter's being handled by your office, when would these payments be credited?
Similar to before with our charges, it would be at or very near to when those payments are received by our office.
And say hypothetically that a payment was sent to the management company or directly to the board or something like that, how would Alliance become aware of a voluntary payment?
One of two ways. Our management company, in this case, so Homeside, as we've seen, they will notice that a payment's been received for a file that's in collections, and they will actually forward the check to us, and then we'll process it upon receipt. If in the event a payment slips through and they do process it to their ledger, as we look at and receive ledgers, we will notice a payment has been received and we'll request that that gets forwarded to us.
Great. And then at that time, would there be an update to your own statement of account, your own records?
Yes, we will update to reflect the payment directly to the association, and then once it's forwarded to us, we'll do the applicable entry to make that update.
Great. At this time, I am sharing my screen once again. I have marked this document as Plaintiff's Exhibit 2A for identification. Sir, do you recognize this document?
Yes.
Can you please explain what it is?
So this is the statement of account, as you see in the heading. This is our ledger that we keep for each individual record that we collect on.
And how did you become familiar with this document?
Through my time with Alliance, this is a very familiar document that we review on a daily basis.
And I am scrolling through the PDF just to make sure that the witness has seen all the pages. This is a document that was previously filed with the court as well, and also is provided to the defendant. At this time, Your Honor, Plaintiff's Exhibit 2A is offered into evidence as Plaintiff's Exhibit 2A.
It's admitted. I have a question. The third line item, these collection fees are more than 50% of the assessments. That is a funny ratio.
I believe, and we'll provide testimony as to that, talking about the numbers, Your Honor. So we can definitely go into the numbers for that. And as to that, could you, Mr. Bodner, help explain to us what these amounts are?
Yes, absolutely. So once a file's with our office, we become the ledger of record. And so we break out all of the charges that are incurred based on the different categories. You'll see ACAS, which stands for Alliance CAS, attorney's fees, which is representative of Mr. Conroy. He'll speak to those. And then HOA, this is a condo, but our label says HOA. So those are the specific charges from the association's ledger for the interest, late fees, miscellaneous items. As you can see, there aren't any in this case, and special assessments as well. And then all the way up to the top is the HOA's assessments as well, or in this case, again, a condo's assessments.
So the first line item, this $11,417.98, this is the unpaid assessments.
That's correct.
Okay, and then the next line are cost. What can you explain what these costs are?
Absolutely. Those are our hard costs incurred as part of the collections process. Usually that is postage more often than not.
And then, so this third line item, what is this $6,700 figure?
That is the total of our collection fees, which you'll see in the second column of charges running down the statement of account. And those are incurred with each step that we take to attempt to collect the debt under our contract with the association.
Could you explain some of the steps that, you know, that Alliance does for this sort of work?
Absolutely. We start out with a placement notice to let the owner know that they've been placed into collections with our office, to contact us. To do that, we have to fully build out a ledger. As you can see in this case, it went back pretty far. So we build that out, produce our initial notice, our initial demand, send that out to the homeowner, give them time to review, potentially dispute if they need to dispute or provide any information to the contrary of what we've received from our client. And then from there, we work through preparing a lien for the association and attempting to proactively collect it. A lot of our clients like to and work with us because we present an option of collections without having to be in the business of taking homes away from their neighbors. And so most often that is what we're able to do. And so each of these steps go through proactive phone calls, emails, reminder notices, and if they prove unfruitful, we move into moving into a recommendation for foreclosure, and then a turnover to, in this case, Mr. Conroy.
So it's safe to say that for your typical collection efforts, you wouldn't see numbers this high.
That's correct. Those numbers would only get there for a file that's been open and unpaid for a considerable amount of time without resolution. And as you look through this ledger, you'll see there are no partial payments. There's no payments received at all, despite our efforts.
Can you scroll down a little, please, so I can see some of these collection fee entries?
And it looks like the fees are over on this side. Is that right, Mr. Bonner?
That's correct.
All right, just stop scrolling. So just looking at December 2020, statement of account letter, $125. So is that really fancy paper? Is it a really long letter? What costs $125 to do a statement of account letter?
The letter itself is inexpensive. It's the work to prepare the reminder notice that goes to the homeowner or owners. But it's that's a reminder notice with a full preparation of their balance.
Looks like monthly in 21, there's a $75 fee for the Recovery Operations Center. What is happening every month in connection with trying to recover unpaid assessments?
So that charge covers our call center, which is where we do our inbound and outbound proactive efforts between emails, phone calls in both directions.
Is there somewhere a record that there was actually a phone call or an email made to this condominium owner each month thus justifying the Recovery Operations Center monthly bill?
We do log every inbound and outbound call, as well as every letter that we send. And we do have records of our emails that we send as well. There is not a guarantee that we will make an outbound call every single month, though.
Okay. I appreciate, I guess this is being passed on ultimately to the condo owner, but it is Abbey Road, which Mr. Conroy has described as a not particularly affluent community, not having a lot of money. They have entered into a contract with Alliance whereby they are basically paying $75 a month for any delinquent accounts that have been turned over to Alliance. They're paying other amounts as well, but it looks like if someone is this delinquent, then Abbey Road Condominium Association is paying $75 a month, in part for this recovery operations center that might yield a phone call to the delinquent account holder.
That is correct. With one note, we do defer our fees to help the association. So they're incurred costs, but they are not receiving a monthly bill and extending capital as it progresses, as we work month to month.
Okay. When would they, it looks like your company was doing work for Abbey Road for several years. Have they not been billed at all, or on an annual basis, Alliance reaches out to say, look, we're doing what we can. This condo owner hasn't paid, so we need to be reimbursed for our efforts.
We continue to defer until the conclusion of the matter to help the association ultimately. So the ultimate hope is to reach a resolution with the homeowner who effectively pays the full settlement amount, and the association never has to come out of pocket for the collections costs. Otherwise, if they close the matter, don't want to proceed forward, then they would receive an invoice from us at that point in time.
Got it. And realistically, in this case, it sounds like this condominium will be foreclosed upon, and when it is sold for more than the amounts I'm seeing here, that's when Alliance's invoice would be paid.
That is correct. And I'll with one additional minor caveat that in the event no one purchases it at the sale, we also continue to defer our fees for about 6 months, and in hopes that the association is able to locate a purchaser after the fact, or if they begin renting the home, we'll continue to defer our fees while they're working that out.
Does it happen often that the condominium association, whether it's Abbey Road or somewhere else, that they can't sell it at foreclosure?
Very infrequent, especially given today's climate with equity in the homes. There's usually a good opportunity for someone to step in and purchase it.
Got it. Okay. But it could happen, and the contingency there is that Alliance wouldn't submit the final bill to the condominium association for a few more months, just in case they could either try again to sell it or begin renting it out.
Correct. And they might keep it, right?
Right.
No one would advise it, but they could turn it into an office for the association, and then obviously would pay our bill.
Sure. Okay. Back to you, Mr. Conroy.
Thank you, Your Honor. I don't have a whole lot more questions, but to make sure that everyone's on the same page. So it sounds like these amounts are actually incurred by the association. The Alliance just is allowing them to defer payment of that obligation until hopefully it gets resolved, essentially.
Yes, that's correct.
Thank you. And then after Alliance has expended and attempted to collect, done everything they feel they can, they recommend foreclosure, as you testified to. Does Alliance continue assisting in the collection effort once it gets transferred to a law firm?
We'll continue to monitor the file and assist as necessary, but we would turn it over to, in this case, you to work the file from there.
So say hypothetically a homeowner were to want to enter a payment plan, but for whatever reason they want to work through Alliance instead of the law firm, is that something that your office would do?
Oh, sorry, I just heard an echo. We would certainly be able to assist in that. We can and do assist in that. We would just, of course, make sure that any legal fees incurred have been considered, since we might not know your legal fees yet.
And in the event that, say, we needed the law firm, whether it's our firm or another firm, needed a updated, figures, things of that nature, is that something that Alliance would assist with?
Yes, absolutely.
And that would be through the process you previously testified to, like obtaining ledgers from the association, double checking with our office how much is owed, things of that nature.
That's correct. And then we'll complete a full reconciliation of the account.
So after transferring the matter over to a law firm such as Conroy Law, Alliance is still assisting with the collection efforts. They're just not actively sending out emails and phone calls and things of that nature.
Yes.
Okay. And then just to continue going through the entries on the statement of account, it looks like the next two amounts are things that I will be testifying to for my firm, but just so we're on the same page, it looks like this $398.22 amount is court cost, and then the next entry is for attorney's fees. Is that your understanding?
That is correct.
Okay. And then what's this next entry, HOA interest?
So that is the interest due to the condo for this file.
Okay. And is it your understanding that this is interest that's allowed under the Georgia Condo Act?
Yes.
And then the next entry I see, it looks like for late fees. Is that accurate?
That is correct.
And is it your understanding that the late fees are also being sought pursuant to the statutory language in the Condo Act?
Yes.
Okay. And then so what's the total that now is owed by this defendant?
The total due is $25,137.44.
And just with all these amounts that are added on the statement of account, is it your understanding that the declaration of covenants for the association allows for the collection of these amounts?
Yes.
And is it your understanding that these amounts were ultimately incurred by the association?
Yes.
Did the association send, and I'm going to go ahead and share, I'll continue to share, I guess, my screen, but I am sharing what I've marked as Plaintiff's Exhibit 2B. Did the association send notice of the association intent to foreclose on its lien?
Well, yes, I want to make sure I'm proper in my answer. We sent this letter on behalf of the association.
Thank you. Thank you for clarifying. So this was part of the work that Alliance was doing on behalf of the association and its collection efforts that sent this notice of intent to foreclose?
Yes.
Okay. And so you recognize this document, is that right?
I do.
Can you please explain what it is?
Yes, this is the 30-day notice. Just if you scroll down, of course, there's a 30-day language in there, letting the homeowner know of their obligations and the intent to proceed with foreclosure at that point in time if the past due amounts are not paid, or at least if contact has not been made to consider payment plans and other options.
And how did you become familiar with this document?
Just over the course of my time with Alliance and in reviewing the document.
And it's a true and accurate copy of the notice that you just described?
Yes, it is.
Great. And I'd also note with the court that this is the same document that was in Exhibit C of the complaint that was filed into this case. At this time, we moved to admit this document as Plaintiff's Exhibit 2B.
It's admitted.
And where was this document sent?
This was sent, you can see this at the top of all of our notices, to 3194 Abbey Road Drive in Decatur, Georgia, 30034. And then just over to the right, an additional copy was sent to 310 Auburn Avenue Northeast, Atlanta, Georgia, 30303.
And how was this document sent?
This was sent via first-class mail as well as certified mail to both addresses.
And how would you know that it was sent by those methods?
We retain a copy of the envelopes, and our system automatically produces the envelopes for this notice to support that requirement.
And who was it sent to again?
It was sent to Home Savers Atlanta LLC to both addresses.
Great, thank you. I have no further questions for this witness, Your Honor.
Okay, neither do I. I've asked mine. Thank you.
Thank you.
Mr. Conroy, what is Home Savers Atlanta? I mean, it's a company, but do they own several units at Abbey Road, or are they one of these we buy houses kind of companies?
I would need to speculate. I've had no communications with the defendant beyond serving them, so we haven't had an opportunity to have that discussion.
Okay.
I don't recall seeing any other properties for Home Savers when doing my own title search on this. However, given the name, I would anticipate that it is some form of company that buys these sorts of units. That does seem to be in my practice. I've noticed that for some of these more modest communities that are condos, that tends to be there tends to be investor owners that like to rent them out. But that is speculation on my part.
Okay.
Your Honor, at this time, I am available to and would like to provide testimony as to the legal fees incurred.
Let's do it.
Thank you, Your Honor. My name is Evan Conroy. I'm an attorney with Conroy Law PLLC. I am the owner operator of a boutique law firm that specializes in HOA and condominium law. I'm able to do this because I have been practicing HOA and condominium law for approximately 9 years. Before starting my boutique firm, I was one of the managing attorneys for a division for community association law. I've been doing all facets of community association law. I cut my teeth for the first 2.5 years of practice out of law school, doing nothing but HOA and condominium collections. From there, I transitioned to a boutique law firm that did mostly real estate and estate planning work. And about 95% of my practice with that firm was in the HOA and condominium realm, where I did both general work as well as continue to do collection work. It is in the regular course of business for our firm to make and keep billing records. I'm familiar with the method in which these records are kept, and they're kept in the ordinary course of business. We've been representing this community throughout this litigation, and I am sharing my screen. For what I've marked for identification as 3A, and that is I recognize this document as the court legal field billing report that our firm made in the ordinary course of business for this matter. It includes the entries that our office, showing the work that our office performed in this matter, and both for myself as well as for a legal assistant that used to work at our firm named Lorraine Kroback, as well as another legal assistant, Selena Hosaka. I was their direct supervisor and monitored their work at all time. There's been approximately 13.35 hours of work, both for myself as well as utilizing the services of paraprofessionals for legal services. Our firm, the way in which we structure our billing is through a flat fee service. This is for the benefit of clients so they have an understanding of how much will be incurred in the typical collection case. That flat fee amount is $2,300. That includes the work for filing the lawsuit, as well as prosecuting the case, filing dispositive motions that need to be filed, and then also attending court appearances as necessary. And then also includes a little bit of post-judgment work, but just essentially sending notices and an initial garnishment. These amounts were actually incurred by our client. I've shown that I am very familiar with this document. At this time, I moved to admit it as Plaintiff's Exhibit 3A.
It's admitted.
Thank you, Your Honor. As previously stated, it shows the work that our office has performed in this matter up until the time in which it was submitted as another business record to ensure that the defendant would have a copy of the document we'd be testifying to today, and was also filed with the court. It does establish the amount at the bottom of the fee that was incurred in this case.
Okay.
Additionally,
And that's the same figure that appeared on the exhibit that Mr. Bodner was narrating.
That is correct. Yes, Your Honor. Alliance does ask us whenever they produce a statement of account to let them know what fees and what costs have been incurred in the case, so that their records can reflect the actual amounts. We being the original custodians of these amounts of these records.
Okay.
Your Honor, at this time, I have marked Plaintiff's Exhibit a document to be identified as Plaintiff's Exhibit 3B. I recognize this document as the document used to keep track of the court costs being incurred in this case. It is also kept in the ordinary course of business. as a billing record. At this time, I offer into evidence Plaintiff's Exhibit 3B.
It's admitted.
Thank you, Your Honor. All this document does is it shows, and there's a little bit of a history, so it goes back a ways, but the work or the cost that are being incurred to prosecute the case, it includes the $213 filing fee, $25 e-filing fee, the $6.88 Odyssey e-filing fee, which is a convenience fee, $50 for an initial service attempt. It also includes certified mail cost to perfect service through mailing as a company of $18.34. And finally, there is the private processor server charge when we attempted service that way of $85. The total cost that are incurred in this matter are $398.22 pursuant to the documents I just described and from my own experience being the lead attorney for this case. Your Honor, the above amounts that we described in Plaintiff's Exhibit 3A as 3 and 3B are apparently customary, reasonable amounts in the Atlanta market for the nature of this type of work. Given the work performed, the time spent, and the total expenses incurred trying to prosecute this case, for my past approximately 9 years of experience doing this line of work, $2,300 seems like a reasonable amount in light of taking a case all the way to trial if needed. And these amounts are being actually incurred by the association.
Got it.
Your Honor, at this time, the association is seeking a final order and judgment in this case, awarding a principal amount through April 3rd, 2023 of $12,539.86. Interest in the amount of $3,077.14. Cost of collections of $6,822.22. The attorney's fees incurred of $2,300. Litigation cost of $398.22. We've been checking the statement of accounts and ledgers recently, and there's been no apparent voluntary payment. Therefore, there does not need to be any reduction in those amounts as there were no payments during the course of the litigation. And therefore, the total is $25,137.44 being sought. Because this is a condominium, we are seeking both a money judgment against the defendant, corporate defendant, as well as an order allowing judicial foreclosure of the association's statutory lien. Our office has prepared a proposed order that we can submit to the court for review and, if necessary, revision.
That would be great. Do you know if the condominium is occupied?
That I am not sure, Your Honor. I don't know at this time if there is someone living there. So that's something that would need to be looked at. I know there were prior service attempts. I do not know if we attempted service at the property address because it was a corporate defendant who owned it.
Okay. If you would get the proposed order in Word format to Ms. Niles, I will take it from there, and assuming everything is proper, I will get it signed and out the door.
Great. Thank you, Your Honor. Your Honor, that was my only matter before the court. May I be excused?
Yes, we will check the docket next week for the Abbott Square case. We'll look for an email from you today that would have the proposed order for the Abbey Road case, and that ought to take care of everything.
Sounds great. Yes, Your Honor. We'll get that dismissal filed this week.
All right. Thank you.
Thank you, Your Honor.
Mr. Williams, you with us now?
Yes, Your Honor. I apologize. We did not have this on our calendar.
All right. So a couple things. You need to drop one of your connections and turn your video on.
I have my video showing me on.
All right. Well, we've
Can you
muted.
hear me now?
Yeah, I can.
Do you still have an echo?
Well, you don't echo, but when someone else talks, it echoes, maybe because the speaker is on your computer.
All right. Is that better, Your Honor?
Yeah, I can hear you now, but there's no video.
I'm not sure what, why that is the case. I had it turned on.
Okay, well, we won't sweat it. You've got two cases. What are we going to do with them?
Well, Your Honor, in both cases, I believe they are ripe for entry of judgment. I believe the Dripping Honey case is first. Is that correct?
Yes, sir.
In this case, we filed the complaint in, let's see, we filed the complaint in August and served the corporate defendant in October. We were unable to locate the individual defendant, Ms. Peoples, so we served her via publication. The defendants have failed to file any responsive pleadings or otherwise appear in this action. Ms. Peoples, as we've indicated in the affidavit that I filed, is not a member of the military. It's not on active duty. In this case, I believe we did have a small actually 3 additional payments totaling $378.96 towards the debt by the defendants after the complaint was filed, but they have not paid the full amount due, which is a principal amount of $9,733.52. And by the terms of the receivable sales agreement, which is a subject contract, there is a in-house collection costs and fees of $2,500. So the total principal amount would be $12,233.52. That's all laid out in the affidavit of Harrison Smallbach, who is in-house counsel at Itria Ventures. I've also submitted an affidavit in support of prejudgment interest and attorney's fees. The attorney's fees shown in here is a flat rate fee that we have with the client that is substantially lower than my normal billing rate. I think all the time in here was actually billed by myself and our paralegal, Milsey Hicks Bird, although Michael Hutchins is also on the case and he has reviewed the affidavit and agrees that it's reasonable. The total amount of attorney's fees we're seeking is $2,385, as well as expenses of $1,316.28. Most of that was in process service fees attempting to serve the defendants. And as I said, we ended up having to serve the defendant via defendant Peoples via publication. We've attached the billing records reflecting the costs and fees that we incurred in this matter, and I submit that they are reasonable for the amount of work we put in, and particularly trying to track down the defendants. And we have submitted a judgment in the principal amount of $12,233.52 with statutory prejudgment interest at 7% equal to $647.54, and reasonable attorney's fees and expenses totaling $3,701.28. So we're seeking a judgment against defendants in the total amount of $16,582.04, Your Honor.
Okay. I think I have a proposed judgment from you. I'm looking at one on the screen here. So I think that all is well with that. Okay.
Thank you, Your Honor. If you would like, I can move on to the other matter.
Let's do that.
This is the case by Itria Ventures versus Roots Business Management and Robin Chardai Roots. This is a case we filed last October, and we're able to serve the defendants by the end of October. The defendants failed to file any defensive pleadings and otherwise failed to appear in the action. Pursuant to the Uniformed Services Military Members Civil Relief Act search that we did, defendant Roots is not a member of the military and is thus not on active duty. that is attached to the affidavit that I submitted. In this case, again, charging it a billable hour rate significantly lower than my normal rate. The time that we submitted in this case was $1,060 of attorney's fees and expenses totaling $888.03. We had significantly less process server fees in this matter. And we're seeking prejudgment interest of $570.67 on a total principal amount of $15,259.76. Again, Your Honor, we've submitted a proposed judgment reflecting that amount for the total amounts of $17,778.46.
So in the Roots business case, your fees are less in part because there was a whole lot less process server and service by publication expense. But I guess you just didn't have to, you and Mr. Hutchins didn't have to work on it quite as much. It either moved more quickly or was less complex.
Yes, Your Honor. I think a lot of the attorney's fees were trying to figure out how we can serve the individual defendant in the dripping honey matter. And so there were some research fees in that, as well as trying to coordinate with process servers and then preparing the motion for service by publication and other associated fees relating to that.
Got it. Okay. What did Roots Business Management do?
I don't actually remember, Your Honor. I believe it's just a consulting firm, and it's named after Roots' name is because the guarantor is last
Ms.
name
Roots. Yeah. Okay. All right. Got it. So let me make sure. All right, we've got a proposed order on that one as well. So I think we're good to go. Do you have anything else in connection with either dripping honey or Roots Business Management?
No, Your Honor. And again, I apologize. I'm not sure how this slipped through the cracks that we didn't have it on our calendar, but thank you for letting me come in late.
Not a problem. Took care of business. Appreciate your time.
Thank you very much, Your Honor.
All right, bye-bye.